Hey Alex, a lawyer and a financial advisor walk into a bar.
Well, then what happens, Dave?
Well, the question comes in is, what do you do when a debtor can't pay you?
Oh, good question. There's been a lot of corporate collapses. Well, every so often a big company collapses, and we all hear about all the contractors who've been left out in the dark.
Yeah.
So that's a big topic, and I think a good one.
Yeah. Well, look at ProBuild.
Yeah, exactly.
Recently,
Yeah.
you look at from a construction point of view. There's been so much
Yeah,
work coming through. You kind of
yeah,
look at that. I saw that and I thought, ooh,
yeah,
that has because with so many subcontractors in
yeah,
that construction field, the ripple effect. I think they,
yeah.
last time I heard, they were talking about like 3,000 creditors that were on the list, and they were asking for an extension of a whole range of things. So very topical at the moment, really.
Yeah, sure. Well, and you normally think, well, if it's a really big company like that, it's not going to go under. I'm fine. No risk at all. They're a very large company. They've got big projects all over Australia.
Yep.
And they were behind in quite a lot of those projects. And then suddenly that's the end of them. And you could have, I mean, if you're a contractor who's been working with them and that's your only client for the last, 6 months, which is the case for some of them, then you're in real trouble yourself because when they go under, there'll be very, very unlikely for there to be any payment at all to the creditors. So typically when companies go insolvent, there's zero recovery, not cents in the dollar, zero. So that's pretty bad.
And that's that question where you turn around and say, well, what happens if a debtor can't pay? Now that comes back to the quantum, even though it may be a really big company or it may be a small company, but if you're saying that debtor is an X percentage of my overall revenue, that's where you've got your risk management sits in there.
Yeah.
But then if we look at that, so with that question, from a legal point of view, what would be the steps that someone would need to take if that situation occurred for them? So, the question that we're talking about today is what to do when a debtor can't pay you.
Yeah.
What are some of the steps from a legal point of view that might trigger that position? Because sometimes it might be just a cash flow issue with that customer that they can't pay for a period of time. Other times it might be, well, there's a whole range of different steps that they might go to that means that you either get a full payment or you get nothing.
Yeah. So I distinguish really, we're talking today about whether a debtor can't pay you, not that they don't want to pay you, which is a different story altogether. So if you're dealing with a debtor doesn't want to pay you because they feel like your goods or your services weren't up to scratch or they, are trying to get a discount or whatever, that's a different kettle of fish where they have the money but they've decided not to pay you. Then you're in dispute territory and, obviously that has one set of kind of legal issues and practical issues. But if they can't pay, so so that's the first question is really, is it a position where they can't pay or are they just saying they can't pay, right? Which is we see that quite commonly. People come to us and they say, the debtor says, I don't have the money, right? I can't, I just don't have the cash. And so the first thing we'd say was, okay, that's fine, but can you prove that? Can you provide us your latest profit and loss statement, or can you show us your balance sheet, or can you show us give us a statement of assets and liabilities or whatever, and swear it and provide a bank statement showing the bank's empty or whatever it is, depending on whether you're dealing with an individual or a big company or so on. And in my view is if it's true, they should be able to do that.
Is that because then they can, from their perspective, that you don't want an organisation to be trading whilst insolvent, so basically that meaning that they don't have the cash available, so therefore they can't continue to operate? Is it much better if a business is in that position that they're saying that they can't pay you rather than they don't want to pay you, is it they're better to be displaying that to say we're putting our hands up and putting ourselves into administration?
Possibly. So that could be an option that's open to them going to administration or liquidation, and we can sort of talk about that. But I think whether you're on the creditor or the debtor side, it's best to be open about it because you really got one set of solutions. If they do have the money, they're just not happy about not paying, and a different set of solutions if you're or problems possibly if they can't pay, and so you just want to be on the same page about that. I mean, the best defence you can ever have in law is I don't have any money. If it's true. If that's the case, play that card. That's and then the creditor, I mean, is in a position where they can go, okay, well, I could bankrupt you or wind you up or whatever, but that if it's true that you don't have any money, that's probably going to lead to zero recovery. So how would that help me? So then you might be able to work with them, might be able to do something else, get money from somewhere else, or accept half, or there's a whole range of things you can do. But you really got to have good data about whether it's true or not, because you get a lot of cases where people say, oh, I can't pay, but they can, they just don't want to.
Yeah, right.
Or they've got 10 creditors and they don't, you're at the bottom of the pile and you need to get up to the top of the pile. So that might mean you need to actually do a statutory demand or take some legal action against them to get to the top of the pile, if you like.
So what are the various steps that someone may, from a legal point of view, you would suggest that they go through if someone is coming to you and says, look, I've got a debtor, which is a substantial debtor, so it's money that's owed to me as the supplier of the either goods or services. What steps would you suggest that someone would take?
Well, obviously, I mean, they have to have a good credit control process themselves internally, so they followed it up and so on. But if they've got a debtor that says, okay, well, I can't pay, in some ways it's too late. In some way, a lot of the things that you can do to secure yourself are done before you get to that point. And, we can talk about that. But if that's the case, I think in looking at recoveries, then you've got to look at the agreement you have and work out who do you have the agreement with. Sometimes you've supplied one company and you've actually got an agreement with another. Your terms and conditions are with, XY Proprietary Limited, and then you actually supplied XY Vic Proprietary Limited. You know what I mean? And you don't distinguish perhaps, but you've got to work out who's your agreement with, what's the actual supply terms, who are they with, who have you supplied. It may be that you've got a claim against both. So you've got to work out who your claim's against, and then look at what security you may or may not have. You might have a charge, like a personal guarantee, against the directors. You might not. You might have a charge against property, so you might have a personal property security register claim. You can actually register against a vehicle or against whatever. You can have a caveatable interest, which is an interest in real estate. There's all sorts of potential security you have, but I suppose we're assuming you don't have any of those things, and you come the company.
Because in that, there can be a lot of people go, really, when you say to them, well, let's work out what the agreement is. In some circumstances, a lot of people, well, we didn't really, we've had an ongoing relationship for years. There's no actual documented agreement.
Yeah, we just invoice every month, and we have for years. And a invoice, there's possibly a quote or some sort of a supply documents, maybe some emails, but that's about it. Yeah, that's right. And it may have been going along hunky-dory for years. But even then, what you have is a course of conduct that constitutes an agreement. So you can show that you've been supplying these people. But then it does become a bit more murky about who you're actually, probably the person you're supplying, and the person who pays are the people who you have the claim against. So you've got to work that out. And it may even be an individual. Sometimes you're dealing with an individual and their sign-off might be a different company than the company you're supplying. So perhaps you have a claim against them. Who knows? So you've got to really work out who is it you're dealing with, and are they the ones who have no money? And if they are the people who have no money, then you're at risk. And so then it's really a question of, well, do you want to issue a court proceeding, do a statutory demand, take various legal claims that you can in order to pursue the debt? And if ultimately that company goes into liquidation and doesn't have the assets to pay, then you don't get paid, and that's that. So if you're dealing with the right entity and they definitely don't have any money and you have no security and they go into liquidation, you can sue them all you like. And you might spend 5, 10, 15, 20 grand suing them and end up with zero. So that's a real risk, and that's just a reality.
And that becomes your risk management strategy that says, is it worth me pursuing this outstanding money that I'm chasing as a creditor from this supplier, or do I just write it off and move on?
Yeah, exactly.
Would you then turn around and say, well, if I know I'm not being paid, should I then be seeking, if I know of any other suppliers to that particular business, to see what their condition is? Because all of a sudden it might be actually they're not paying me for a different reason, as opposed to, they're saying they can't pay me, but someone else might say, well, look, I just got a payment made, last week, and therefore I don't have anything outstanding, but I was about to make a delivery of something.
Yes, certainly. So that's a really great point. And you can certainly, in the statutory demand process, that you can be what they call a supporting creditor. So you can actually, if someone else is pursuing a company, you can jump on and pursue them as well, or vice versa. And sometimes if you find out from other creditors that they're getting paid and they tell you, well, they can't pay, you say, well, you can obviously pay someone. So why don't, as I was saying, you want to go up, you want to basically make some noise. So pursue them, in a legal way, sue them in court, or make it statutory demand, which is kind of an insolvency process. And they'll have 21 days to pay, and if they don't, you can apply to the court to wind them up. So that's pretty severe. And if there's any question about whether they can or they can't, that'll get to the bottom of that, because if they can, then they probably will, and you'll probably be at the top of the pile. And we deal with a lot of that. There's a lot of people who, look, they say they can't pay, but they have some money. There's some cash flow.
And so tucked away somewhere.
Yeah, that's right.
But is there a dollar figure that you turn around and say, well, if it's anything that's under 50 grand, depending upon the size, or as a percentage of the turnover of the business that you're taking, is there a point where you say, look, really, one is either I'm going to pursue them because it's an ego issue that bugger it, I supplied them with stuff and you can bloody pay me.
Yeah.
Or you just say, righto, I'm just going to have to write it off and move on.
Yeah.
You just then put yourself down as a normal creditor and hope that something comes back in time, but write it off and move on.
There probably is. They're probably different in different circumstances. So, I mean, I'd say you can pursue virtually any debt if you're willing to, say, do it yourself in VCAT, because you can sue a small claim in VCAT, costs you something like $35 to file the proceeding. You can run it yourself. You know, it's a bit of a pain in the butt, right? And maybe you don't have time, but really the only cost is your time and the sort of hassle. So you can do that to pursue virtually any debt. But if you're going to hire a lawyer, then obviously there's going to be a costs component. Now, you can recover your costs from the other side if you're successful, but you may not be successful. They may become insolvent and not be able to pay you. And in any event, even if you're successful and you get paid your costs, you're definitely not going to recover all of your costs. So there's a sort of an out of pocket. So I'd say when you're talking about 5 or 10 grand, that's the range that's probably pretty difficult to pursue in an economic way via a lawyer. But over that, and typically when you issue debt recovery proceedings, they're often paid virtually straight away. So you might spend $1,500, recover your 12 grand, and maybe get a cost component, recover $600 of the $1,500 that you've spent. So things are looking pretty good. But we're really talking about where the other side has no money at all. And in that case, if we're confident they have no money at all, then spending any money on it's probably a bad idea. But I think you really want to make sure that they really have no money, that it's not just a case of that you're I think it's like the ProBuild example is a good one, that probably a lot of people were getting paid and everything was hunky-dory, and then ProBuild suddenly went into administration, which means they suddenly don't have to pay their debts anymore at all, and then they'll go into liquidation, and I think the liquidator will sell part of the business. And there may be a return to creditors as a result of that. But basically, you just take a number and hold on and hope for the best. Yeah, and that could be,
so the topic that we're talking about today is what to do when what to do when a debtor can't pay you, so you're owed money from a business. Yeah, that's a really interesting one when you kind of, if they put themselves into administration, which is the directors of a business, basically putting their hands up in the air and saying, we are drawing a line in the sand, we're going to limit our exposure, but you, as an individual or business that is owed money, you just basically get onto the queue of, okay, we might get, part of it then becomes I'll get some money, I may get all of it, I may not get anything. But it's a management. But I also think as part of that process, we've got to remove the emotional component to say, bugger it, I've been delivering all of this, because it's this ripple effect. You might be relying upon this information from this supplier, but you then owe money to other people. So it puts you into this cycle that you've then got to kind of manage where some of your outstanding payments are going to be. So, the ripple effect, and I do think that ProBuild, very topical in sort of March 2022 that we're looking at, is that ripple effect with so many different individual subcontractors that work inside that construction industry. Just has so many, because that sometimes is their sole. They may be on that one particular site and know that they're on there for 3 months or 6 months to do one particular specialist job before they move on to the next one. And they actually don't have any other revenue stream because that's the only job they have.
And what's worse often is, and it's something that people don't really understand, so you might be sitting on a site working away, everything's great, you're getting paid, and then the company goes into administration or liquidation. They basically, once they go into that process, they no longer have to pay their debts, and you can sue them all you like, but you won't be able to recover until the liquidation process is complete, and then they'll make a decision, and then they'll pay everyone whatever's left. And if you go into that, if you've been working away and getting paid and everything's hunky-dory, then suddenly this liquidation happens. You might have, say, 2 months of work that you haven't been paid for, and you think, okay, well, that's pretty bad. I've lost 2 months worth of work. Very bad indeed. You're waiting to get paid, hopefully, for that 2 months. But worse than that, you may have been paid for the previous months, and actually there's a rule in liquidation that says that the liquidator can recover any payments that are made to creditors within 6 months. So the liquidator, from when they're insolvent, it's all a bit technical, but effectively they can say to you, well, there was two creditors, you got paid and the other creditor didn't, and so I'll have your money back and I'll split it and give it to all the creditors equally. So you actually may end up having to repay amounts, legitimate amounts that you got paid for work you legitimately did, but you got paid in preference, you got paid before other creditors, and so you have to repay it, and then they'll make it all fair amongst the creditors. But it might mean you've done legitimate work, got paid, then you've done some more legitimate work, not got paid. You go, oh, well, I want to get paid the money that I'm owed. And in fact, you've got to repay money that you've already been paid, which is just an absolute kick in the guts, right? And people don't really understand it, think it's pretty unfair. And I can see on many views it is unfair. They're trying to be fair amongst the creditors, which I can, obviously I can see the logic in that, but it bloody hurts when you've done work, got paid, and then done more work, not been paid, been stung for that, and then you get stung again having to repay the work that you legitimately did and were paid for. So, I mean, that's just an awful process.
And the other thing that sits in there, which a lot of people don't realise, if they've delivered materials to that site, and they're waiting for those materials to be installed onto that site, once that nomination of administration has been, that site is locked out. So any assets that are sitting on there, unless you've got them on the register, it's like, well, they're gone. They're not part of the creditors' process that the administrators that get appointed have control of.
So people go, well, that's my equipment. I haven't been paid for it. That's my steel or whatever. I'll go and grab it. And you can't. It's the liquidators because it's been delivered. You're absolutely right. And it's worse than that. Even if you've rented stuff to the site, so you're a hire business that hires out cranes, and your crane's sitting on the site, then that's the liquidators. Unless there's a personal property security register, like a special registration made on the register. Now, businesses that are in hire normally do that as a matter of course, and hopefully. Most businesses do it when they supply equipment, but some don't. And the PPSR, it's called, those registrations are hugely powerful. They're relatively new. They've only been around, 5 or 10 years. It's what used to be called, a fixed and floating charge, or a retention of title clause in the contracts. Old people like me remember that.
Now
it's just PPSR. That's all there is. But it's hugely powerful, and it costs you $10 or something to make a registration. So it's certainly in your interest. And there's law firms that can do it. There's some accounting firms do it, and you can certainly do it yourself if you're supplying goods, and it's absolutely worth it. And that's probably what we should talk about next. What do you do? And this all sounds doom and gloom, but what do you do to protect yourself from this? How do you have a better risk mitigation strategy so that if one of your customers goes in under, that you've...
Because it's these little things. It's this cumulative effect of the little, as someone says, it's a bit like the pebble dropping into the pond. The ripple effect goes out wider. Unfortunately, with some of these bigger administrations, it's a boulder being dropped into the pond and not a pebble. Because the ripple effect is just so great until you can work through on some stuff. But just a quick question, when you talk about administration versus liquidator, where's the crossover point and what's the distinction between the two?
So an administrator any of these insolvency practitioners, administrator, liquidator and receiver, they're all very similar. The three of them, once they're appointed, formally appointed, then the directors of the company are no longer in charge. Directors are out; they can't do anything.
Their exposure is also capped too.
That's right. Yeah, they're out, and they're to the extent they've done anything wrong, that finishes when they get kicked out. So their liability is limited from that day. But they lose control of the company, so they can't decide what to do anymore. They're completely out, and the administrator or liquidator or whatever they are makes all the decisions. And there's law that says then there's like a moratorium on debts where you can't sue them, you can't make a claim against a company that's in liquidation. The liquidator has to do their job, sell all the assets and so on, and then pay out the creditors kind of in priority. So they pay themselves first.
Correct.
I mean, let's not be silly. They pay themselves. Why would you do it otherwise, right? And then they pay the secured creditors and so on. They pay the staff, and then they pay unsecured creditors basically last. So if you're just a regular creditor who doesn't have a mortgage or anything, you're at the bottom of the queue, and you get paid equally. Or you get paid the same cents in the dollar, across the board. So it might be everyone gets nothing. It might be everyone gets 5 cents in the dollar, 20 cents, 50 cents, maybe 100 cents in the dollar if there's lots of assets. But it could be years down the track too. Yeah, it takes a long time, and in the meantime, basically, you put in what they call a proof of debt, which is just a document that says what you're owed and why, and the liquidator says yes or no. And often they usually accept them if they're legitimate,
Yep.
and then you just wait and hope for the best, right? And
Yep.
so it's not a great process. There's some reports that the liquidator does. Let me just go through the difference between the three, because that's something people talk about them a lot. They chuck them in the same group, but they are slightly different. A receiver is effectively by the bank to deal with mortgaged goods or secured charged goods only, or charged assets only. So they typically, the bank that has the big mortgage facility or whatever, they'll deal, and then once they're finished dealing with the secured assets, they can hand over often to a liquidator who then deals with the rest of the assets. And a receiver is so what did I say? I said receiver, liquidator. The liquidators, basically the job is to sell all. So once you're in liquidation, that means you're selling off that you might sell the whole business, or you might just sell bits and pieces of the business, or recover whatever debts you can, collect as much money as you can, and then distribute it to creditors, and it's all over. Yep. Whereas an administrator, their job is to look at the business and see if it's worth trading on and continuing and coming out of administration. And you can actually appoint an administrator, work out that you've got some debts, deal with those debts, and then come out of administration and go back to trading. Whereas once you're in liquidation, it's the end of the business. So and often what happens is, yeah.
So you're really saying an administrator can be appointed to start with.
Yeah.
So
Yeah.
the directors of the business would say, right,
Yeah.
we're going to appoint an administrator, therefore they cap their exposure. They
Yeah.
come in, they reassess the business. The business
Yeah.
will either be we can break it up, or we can package up components of it and keep it continuing, but there's an agreement with the outstanding debtors that are sitting there that might be, well, we will forego X amount of
Right,
the business is still viable. Like it
Yeah.
might be a refinance requirement or whatever may need be required. Then you're saying the next tier down is a liquidation that says the business is not functioning, as an ongoing entity. We are better based upon the assets that are available to sell them, which is
Yeah.
to liquidate the asset base
Yeah.
that we have to provide cash to then pay down to creditors.
Yeah, exactly.
Yeah.
That's probably clearer than I put it.
Just in layman's terms on it.
Yeah, well, that's right. I mean, administrators are looking at, is it worth running? And you can come out of it, it might be that all the creditors go, look, I'm happy to take half because I think it's a good business, and I'll continue to trade with it in the future and make money out of it. So I'm happy to just allow it to trade on, you know what I mean, and do what they call a deed of company arrangement, which is, an arrangement where the creditors each agree to take some sort of discount. And sometimes they take a discount that wouldn't be, they take a payment that would not be available if the company went into liquidation. So the director, for instance, might go, well, look, I'll give the company some money to pay some of the creditors just to get over this hump and continue on with the business because I think it's a good business. But it's very common that once an administrator is appointed or a receiver is appointed, that it goes into liquidation pretty quick. So, it's a good idea. It sounds good that, you're going to have a look at the administration and work out whether the business is viable and all that. But it's very common that they're not viable and that they just go under, and that's that. Most of the ones I deal with, most of them go into liquidation virtually straight away, and most of the creditors get zero. So that's the most common outcome. It doesn't happen always, of course, and, you'd look at all businesses are different, but I think that's the position you should sort of expect as a default, because that's pretty common.
Yeah, so really, I know, which is brutal, especially when you've done a lot of stuff. Even though there's an agreement in place, a lot of stuff is done on good faith. Like we have a commercial agreement in place, but we're delivering services and goods in good faith that the business will continue unless we can see some signs of it. But I'm just sort of from a point of view, if we're going to kind of wrap up on this discussion around, what to do when a debtor can't pay you, it would seem based upon that one of the first things that someone should do is seek some advice.
Yeah, you want to see where you stand. Does the other side really have any? Get some intelligence on what the debtor's real position is, and seek some advice about what it means if they go into liquidation or whatever for you, and who's your contract with, what security do you have, all that sort of stuff. So absolutely, get some advice. And I mean, the ideal situation is you review these things before they're a problem. You ideally look at who have you got a contract with. Do you have personal guarantees against the directors? Do you have property security? Have you registered the PPSR? All of those things give you huge, much better rights than you would have if you're just, invoicing the same old dudes you've been invoicing forever with no written agreement and no security at all. And that's fine until it's not.
But also being aware of what your early warning signs might be. Yeah. Where normally they pay at, 30 days, but that's now
Yeah.
stretching to 45 to 60. You know,
Yeah.
there's some early signs that you've got to be across, you know,
Yeah.
in running your business to say, well, why are these people taking so long to pay me?
Yeah, because then you're just going further backwards. And I think
Correct.
clients who come to us are in big trouble who really should have taken action, 60 days ago, and they've continued to supply. So you've got to stop supply to put them on cash on delivery or whatever straight away. And be tough. I think if there was a lesson in all of this for me, it'd be you've got to run a tight ship. And it's the ones that get loose that end up being the problem. And so if ultimately you have to move on from working for a particular customer because they don't pay or they're always late or whatever, then that's a good thing. It makes your business healthier. You know what I mean? Now, hopefully you'll have other customers that you can work for, and I appreciate coming by new customers is not always easy, but people who don't pay you are not good customers.
Yeah, like you're not a charity. So in the end, if you're delivering a service or product, you need to be paid.
Yeah, and you owe it to you got to pay your team, you got to pay your suppliers, you owe it to all of them to be requiring payment from your customers and requiring appropriate security. I mean, if you're going to deal with a small company, or in this case ProBuild, right? You're going to deal with a massive company, and the directors say, well, I'm not signing a personal guarantee. You go, okay, why is that? I'm not giving any property security. Oh, well, why is that? They say, well, bad luck, especially a small company. Sort of like, I mean, I sign directors' guarantees for Taurus all the time, right? I've got one for my lease and one for the any finance facilities, all these sort of stuff. Anyone who knows what they're doing requires a personal guarantee. So why wouldn't you get a personal guarantee? And if you're not getting one, maybe you shouldn't be doing business with that person, or at least they should be cash on delivery or something. Yeah, that's right. So there's lots of things you can do, but the best time to do them is before you're in trouble. After you're in trouble, obviously you get some advice, but taking the right steps early makes all the difference. I mean, caveats and property security make all the difference in terms of recovery.
Which I think part of the lesson out of the discussion today is just assess your customer base and see and just get a feel. And if you feel confident that they're trading well and everything's good and you've got a good relationship with them, great. But if you've got some early signs that you're not sure, then I would be, looking out and reaching out to seek some advice on what is an appropriate approach to take with the client.
Yeah. And actually, I've done it. I should just plug myself, as I love to do, as you know, Dave. My favourite is to plug me. I've done a couple of videos which are on the Taurus Legal Management website, so and on our YouTube channel. So if you look at them, there's a couple of videos on what to do in terms of, do you do a statutory demand? Do you issue legal proceedings? There's a bit on debt recovery in there, which is helpful if you're facing something like that. And it's all for free.
Yeah, gee, you just we don't mind a bit of self-promotion, do we?
Yes, that's right. All the answers are on there. You can watch a video of my face, which I'm sure people are just...
All right, well, I think we better wind that up for today.
Yeah.
I hope people have found that enjoyable, and I think really the lesson out of that is, what to do when a debtor can't pay you is the key is, seek advice and don't stick your head in the sand and just hope it'll go away, because if there's early warnings, it's time to jump on it. Yeah. All right. Well, thanks once again, Alex. The words of wisdom and the discriminatory of self-promotion is always present.
There's another thing that I'm great at.
Yeah.
All right. Thanks, Dave. Nice to
see you on the next one.
See ya.